May I, my lord? My lord, item number 21, my lord. I am for the respondent victim, my lord. I am not prepared. Can it be listed after 2 weeks, man? I've taken the consent of the appellant.
21 is connected. 21 is connected to 22.
22 years, man.
Okay.
Same case, man. There is 2 accused person.
When do you want 23 matters criminal appeal? You would not like to
After 2 weeks,
done
man.
for a long time.
2 weeks, man.
Not 2 weeks.
After a week, then.
After a week, we'll fix a
Right.
date.
Yes, man.
A prayer for adjournment has been made by Sri B. Picha, learned counsel for the respondent. Accordingly, matters are adjourned to be listed on today's court. We'll have it on next Thursday, 11th,
11th, man.
on 11th, for hearing,
My lord.
11/6.
Obliged, man.
May your lordship. Lordship, I beg to mention item number 3 on behalf of Mr. M. Chanda.
Item number
3, your lordship.
3. Yes.
Readings are completed, your lordship. This matter may be fixed for admission hearing.
It's for admission hearing.
Admission hearing.
Yes, your lordship.
Item number
Item number 3,
on
Your
behalf of,
M. Chanda. M. Chanda, your lordship.
we are taking up for admission hearing
I'm making a mention, your lordship.
for adjournment.
Yes, your lordship.
23
behalf-
matters.
On behalf of Mr. M. Chanda, your lordship, can this matter be fixed on 21st of July after summer?
No,
break?
not that much. 23 matter. Why 21st of July? We are in the, on 4th of,
Yes, your lordship. Respondent number 2 was supposed to file. They have already filed affidavit recently.
no, we'll grant some accommodation, but not that long.
Lordship.
We'll have this on 16th of June. 16th of June, Tuesday, hearing day, DBD. A request for adjournment has been made on behalf of Sri M. Chanda, learned counsel for the respondent. Also heard Sri R. Sikya, learned senior counsel for the appellant.
Read petitioner, my lord.
Read petitioner. Read petitioners. Para? Considering that this matter is pending since the year 2023, a slight accommodation is granted directing listing of this matter on 16/6 for admission.
Obliged.
Kato for Sri M.
Malad, I am for Union of India, Malad.
Sri M. Kato, learned counsel for the learned deputy SGA is present.
May I, your lordship? Your lordship, I'd like to mention item number 11, your lordship. My senior Mr. Legam, the legal aid counsel in this matter. Your lordship. He is out of station on medical purpose. Your lordship.
Okay. On a request made on behalf of Sri L. Nochi, learned legal aid counsel, matter is adjourned to be listed on 16th of June.
Your lordship. So maybe it will be difficult for him. He's in medical.
So we're granting 2 weeks time, 23rd of June,
Okay, I'll
23/6.
much obliged.
May I please, Lordship? I beg to mention item number 23. The legal aid counsel is unable to come due to some personal inconvenience. Lordship, kindly may this matter be fixed after few weeks.
Legal aid counsel for the respondent or the petitioner? Appellant, which one?
Lordship, C is for appellant, lordship. I am for respondent.
Mr. You are making a mention on behalf of Mr. Buri.
Yes,
Buri,
Lordship.
okay. On a request made on behalf of Sri U. Buri, learned legal aid counsel for the appellant, matter is adjourned to be listed on 11/6, madam? 11/6.
Yes, Lordship.
Obliged.
Much obliged.
Item number 1.
Met your lordship.
Yes.
Well, this is a contempt petition, my lord. Earlier, by a judgment passed on 13th of February 2026, my lord, in a writ appeal, your lordship directed to redo an exercise for the promotion because we were promoted to the post of estate engineer prospectively. We filed the writ petition claiming retrospective promotion, which was dismissed. On appeal, if your lordship kindly comes to page 37, the operative part, my lord, at paragraph 26.
37.
Your lordship space, my lord, page 37, paragraph 26.
Yes.
And it says, in view of the aforesaid facts and circumstances, we are of the view that the matter is required to be reconsidered by the department. The department is accordingly directed to redo an exercise with regard to availability of vacancy from the date of officiating appointment of the appellants. And if such vacancies in the promotional quota in the cadre of estate engineers were found to be existing, the appellants be given the benefit of seniority from such date. It is needless to say that the appellants, if found to be senior, they would be entitled only to the notional benefits. The aforesaid exercise be undertaken and completed expeditiously and preferably within an outer limit of 90 days from the date of receipt of a certified copy of this order. My lord, we produced the certified copy of the order on 16th of February 2026 along with the representation. And my lord, till date, nothing has been done.
Heard. Notice. Heard. Pre-D. Mazumdar Learned Senior Counsel appearing online for the appellants assisted by Sri.
Pankaj P. Boraman. Yes,
No,
yes,
he,
ma'am.
we got Bagam who is present personally. Para. The petitioner has complained about willful and deliberate disobedience of the order dated, judgment and order dated 13/2/2026, passed in WA 35 AP 2024. Full stop. Attention of this court has also been drawn to the representations submitted requesting for compliance of the direction, which however has not been complied with till date. That notice be issued returnable on returnable on 1st of July. Is it okay? 1st of July.
Ma'am.
1st of July 2026. Let steps be taken for service of notice upon the respondents by speed post with AD.
Obliged.
Obliged.
Item number 2.
Your lordship, this is a similar method to item number 1, your lordship. The writ appeal is writ appeal number 28, and I have submitted my representation on 17 papers.
Same day, same order.
Yes, your lord.
Judgment is the common order.
Yes, common order.
Okay.
Only the writ appeal number is.
Your IBAM,
Yes, your lord, I got.
heard Sri IBAM, Learned Counsel for the petitioner. One petitioner,
Yes, your lord.
who by same, huh? Who by the Learned Counsel has also. Your representations has also same one.
17 to.
And respondents are the same.
Same, your lord. I have my 2 container.
Even they have made 2 respondents, same, speed post to AD. Here only petitioner is one. 6 steps by speed post to AD by tomorrow.
Yes.
Item number 4.
May I please, Lords. My lord, I have filed one IA, my lord. That is IA number 123, my lord, of 2026, my lord.
Are you for?
My lord, I am seeking direction from this honorable court, my lord, to the respondent number 2, to, my lord, bring the record with regard to, my lord, one-man commission report, my lord.
Yes, madam, what do you say?
Notice will be issued, my lordship. We'll file a with them.
Now, is the report ready?
My lord,
the first
is, my lord, is per, my lord, page 12 of my IA, my lord. My lord,
Can this report be brought to public domain?
my
There
lord,
is
that,
one aspect.
my lord, that's why, my lord, I'm file this IA, my
Your response, madam, you also take instructions on this aspect, whether this report is a confidential report or whether it can be brought on public domain. Okay. Have you applied for the report?
Yes, my lord, I have applied for the RTI, my lord,
RTI,
but they have denied.
Answer? What is the answer?
Answer, my lord, my lord, page 14, my lord, they have said that it is, my lord, exempted under section 8(1) E, G, and H of RTI Act, my lord.
Madam, you take instructions whether it can be,
Okay.
at least you can, the report, if there is also a restriction, without serving a copy, we can be a privy to it. You
Yes,
can
ma'am.
bring it and we can see you take instructions, okay?
Hello.
Heard 3H Lampu, learned counsel for the applicant, who by means of this application has sought for a direction for production of the one-man inquiry commission report conducted by so-and-so, see from the cause in the matter of till the date, fiasco सब कुछ लिखा हुआ है. First page only. Let notice be issued. Returnable on
15 crore.
why are you issuing notice? You take instructions.
Yes, my
Yes,
lord.
Miss Wang Mu,
Yes, ma'am.
London State Council, prays for some time to obtain the instructions. Sarah, in view of the above, matter is adjourned to be listed on
16th, my lordship.
16th of June.
Yes.
16 June, to enable the London State Council to obtain the instructions.
Oh.
Miss Anne Anju, London Council is present for the APPSC.
Lordship.
That extra copies be served upon the Learned Council for the respondents during the course of the day.
My lord. And
Item number 5 and 6. Lordship,
My lord,
we need, I need some time, Lordship, because brief is not with me, Lordship.
my lord,
IA for
IA from, my lord, claiming the juvenile of the applicant.
you're claiming juvenility of the appellant.
Yes, my lord.
Was the issue raised in the trial?
My lord, it was first time raised in this court.
Okay, you can still raise it. Madam, what do you do in such a case? You need to have conduct an inquiry in
Lordship,
accordance with law. But the matter will have to go back to the Learned Trial Court.
Lordship.
Today is for the first time on the IA.
Lordship,
No, my lord.
IA is for the first time.
No, my lord, this listed several times.
Earlier, earlier it was listed.
Yes.
Notice was issued in fact. 24, since 24 is pending.
Lordship.
My lord, on 13/5/2025, the learned PP sought 2 weeks time to obtain instruction from the concerned police station.
Lordship, yeah, this other Lordship, additional PPT Genie is appearing this matter, Lordship.
Who's the parent?
DT Genie, Lordship.
T. Ginny.
Yes, Lordship.
G. Ginny,
Yes,
okay.
Lordship.
Okay. Can we have on Tuesday?
Yes.
Okay, let her colleague come.
Lordship.
What is your name?
Omori.
Omodi. Heard Sri Omodi Learned Counsel for the applicant. Where, however, a prayer for adjournment has been made on behalf of Sri
T Genie, Lordship.
Miss
Yes, Lordship. Miss T
Miss
Genie.
T. Ginny, Learned APP,
Lordship.
who is entrusted with this matter.
Yeah.
Sarah, in view of the above, matter is adjourned to be listed on Tuesday next.
Lordship.
Give the date, please.
9/6.
9/6.
Much obliged, Lordship.
Please inform her
Yes,
and
Lordship.
ask her to have the instructions.
Yes, yes, Lordship. Item number 7 and 8.
Seven,
It is out of same FIR, Lordship.
seven,
Same incident, 2 FIR.
okay. Seven also juvenility.
Yes, my lord.
Okay, seven, same
Yes.
order.
My lord, here a notice was served to the office note. No, notice was served to the respondent.
That's but nonetheless, let her have the instructions. We'll have it together on Tuesday next.
I'd like to. Item number 9.
But how was Tarak connected?
Eight, I am amicus query for appellant. Eight.
Then record his name also in the RD. P. Tarak, learned counsel, learned amicus curiae for the appellant in criminal appeal 4 of 2023 is present. Yes, Mr. Tarak.
The short question involved is whether the circle officer under Arunachal Pradesh Land Record and Settlement Rules 2012 has the power to issue the LPC or not. Now, in another matter, where Lordship has dealt with in read petition number 74, there Lordship has held that the circle officer, but here the case of here Lordship was dealing with the DLRSO. Now DLRSO and the circle officers are empowered under the Act, my lord, to issue the LPC. My lord.
Yes.
So in that view, then we relied on my lord's judgment on the similarly situated fact. The only thing I pleaded before the honorable single judge was that yes, there is a power under section 4 of the Arunachal Pradesh Land Settlement Record Act, section 4, subsection F, and then read with rule 6F also has the power that they have designated the circle officer to issue the LPC. But where the honorable single judge could not agree, then I raised the point that was not recorded. I said, my lord, the coordinate bench has already held on the similar situated fact when the Act itself provides that yes, circle officer and DLRSO both can issue the land possession certificate in Arunachal. Now, as a revenue officer, my lord, can I have this Act?
Yes, Mr. You for whom?
I'm for HPCL, Lordship.
HPCL.
Volume 8. Page,
And
My lord, I am for
Seven,
respondent
seven.
number 1 on behalf of M. Kato, my lord.
you're for this Union of India.
Yes, my lord.
Who is for the private? Is there any private respondent, Mr.
7.
Tara?
my lord?
Is there any private respondent?
No, my lord.
No problem.
Only a small question of law, madam, whether the circle officer under section 4 of the Land Settlement Act 2000 has the power to issue LPC or not, my lord. That is the only question of law to be determined.
Who is for the state?
State, nobody is there. Because the HPCL, my lord, they have issued an advertisement.
This is an issue where we need the assistance of the state. Essentially, your list may be with the HPC and the Union of India.
Correct.
Sorry, my lord. Yes, my lord. There are certain, my lord, limitation. My lord, some around 5,000 acres. I think this is the competent. Beyond that, my lord, Secretary Land Management, my lord. The approval is to record. So, my lord.
We'll do one thing. We'll direct Mr. Tara to hand over a copy to you, and you assist the court in the next hearing.
Very well, my lord.
Okay. Yeah.
LP.
And you can also seek some instruction. We'll grant 2 weeks time. Okay. Heard Sri T.T. Tara, learned senior counsel, assisted by Sri G. Bam for the appellant. Also heard Sri T. Tapak, learned counsel appearing for the HPCL, and Sri
M. Sora.
and Sora, learned counsel appearing on instruction of Sri M. Kato, learned deputy HGI. Full stop. Para. The issue which would require a determination is on the power and authority of the circle officer.
Correct, under section 4.
Issue land possession certificate. Full stop. Since the issue would require or would involve the the issue would require the inputs from the state. Full stop. Accordingly, we request Sri R.H. Nabam, the learned AAG, to assist this court to resolve the issue. Para, let a set of documents be served upon the learned AAG during the course of the day by the learned counsel for the parties. Let this matter be listed for consideration on, we'll have it on 23rd of June. Is it okay?
Fine.
23rd, Tuesday.
My lord, kindly upgrade to admission column.
It is an admission only.
Admission? Orders column.
What is it for order?
Item 9.
Who are 2, 3, and 4?
That's by SPCL.
SPCL already there.
SPCL is already there.
Union of India, who is this? Mr. Kato.
Kato.
Respondent number 1 is by Mr. Kato, learned DGSI.
Since this court, via the order dated 13/11/2025, has recorded that service is complete, list for admission.
Interim order.
List in the admission column.
Yeah. Interim order to continue, my lord.
Interim order passed earlier to continue till the next year of list.
Grateful, my lord.
Item number 10.
Item 10, yes. Legal Aid Council. Atum Lemnio. Where is Mr. Lemnio?
He was appointed as
Name is reflected in the call list. Is he around in the court?
Today,
Hmm? None appears for the appellant on call. Whereas Ms. El Hagelanet APP is present, para. Wide order dated 29/8/2025. The records of the learned trial court were called for. Records have come, madam. Pursuant to which the said records have been received. Para. We have, however, noted that the appeal is yet to be admitted. Para. Admit for hearing. Admit for hearing. Let the paper book be prepared by the registry. And conviction under 302. Okay. List for orders after preparation of the paper book so as to fix the date of hearing.
item number 12.
May it please your Lordship. The petitioner has challenged the order of UGC, my lord, to deny the permission to run open and distance learning courses and online courses, my lord. UGC has filed the counter affidavit in this matter, but UGC, my lord, in the counter affidavit has not adverted to the specific pleas which we have taken, saying that similarly situated institutes or have been granted permission, my lord. So, and UGC is the main contesting respondent in this matter, my lord. UGC has, in the counter affidavit, my lord, has only dealt with placed the regulation, and that's all, my lord. Not no answer to the grounds with regard to discrimination, my lord.
Would you like to file any rejoinder?
No, my lord. The only legal aspects have been placed, so therefore I would not file. I would not prefer to file, my lord.
Who's for the UGC?
My lord, I am for the respondent to UGC.
Yes.
Respondent number 1, madam.
Yes. Can we take up this matter for consideration?
My lord, here, respondent number 2 is also there in Union of India, madam. Two, madam.
Madam Sangeeta, you are for whom? For? 3. Chief Secretary. And union is there.
Yes, my lord.
Who is for the Union of India? Mr. Kato? And anyone with Mr. Kato, somebody was there? Would you like to respond to this writ petition?
Ministry of Education.
You're Mr. Kumar, Amit Kumar.
Yes, my lord. Yes, my lord.
Mr. Kumar, does the Union of India has a role in the list?
My lord, so far as Union of India is concerned, my lord, the regulation is by UGC, my lord. But in UGC, in the counter affidavit has disclosed that it was weighted by the Law Department of Union of India, my lord.
Okay, then we'd like to have your views.
Yes, Your
This
Lordship.
is pending since 2025. Why haven't you filed your response till now?
Your Lordship, we were not quite aware of this, Your Honor. We would like to take a proper instructions, Your Lordship.
Your names are not reflected in the cause list.
Your Lordship,
Item number
12, my lord.
12. Oh, your name is not there. Okay. Third, your A. Kumar.
Amit Kumar.
Heard Sri A. Kumar, Amit Kumar, London Senior Counsel, who has appeared online for the petitioner. Footstep. He has submitted that the contesting UGC has filed the counter affidavit on 1/6/2026, certain important issues have not even been addressed by them. Para? Sri, your name?
Your Lordship, K. Terry.
Sri K. Terry, Learned Counsel, appearing on instruction of Sri M. Kato, has however informed that though the Union of India is a party, right?
Yes, my lord.
Their names have not been, the names of the learned CGC have not been reflected in the cause list. Full stop. He has prayed for some time to enable obtaining of instructions. Para? You suggest a date, Mr. Kumar? Will
First week of July, my lord. First week of July is.
first week of July will be vacations here. We can have it on 21st of July, immediately after the vacation. List on 21st of July, by which time, response by the union be filed if so advised.
My lord, and my lord, one thing, my lord.
The name of CGC be reflected in the cause list.
My lord, respondent number 4 is also there, my lord.
Who's for?
Department of Education, Government Varnachal Patel.
Yes, there is Miss Madam Sangeeta is there.
There is a standing council.
Who's the Senegal? Tagum?
Yes, my lord.
Where is Mr. Tagum? Is he around? Do they have a role?
No, my lord, they have no role in this matter, my lord. UGC and central government, they are the only.
The name of the Standing Council, Education Department, may also be reflected in the cause list. Okay.
Much obliged.
Item number 13 and 14. May it please your lordship, I'm appearing on behalf of Legal Aid Council Uttam Bori. The Legal Aid Council has instructed that they have filed the condolation appeal.
Mr. Bori was here. Why did he disappear?
No, he was not here. He couldn't come. He couldn't come.
This is an application under what?
Condolation.
Under what provision of law?
What's called please? POCSO.
The application for condemnation is under what provision of law? Where is your brief? You should come slightly prepared. What is about? What is section 5? What is the period of limitation? And how do you take steps, madam? Have you seen the description of the parties? 2, 3, and 4? Okay. What is your name?
R. Singh.
R. Singh.
Yes.
Heard Miss R. Singh, Learned Counsel, appearing on instruction of Sri U. Buri, Learned Legal Aid Counsel for the applicant, full stop. The instant application is filed under Section 5 of the Limitation Act 1963, praying for condonation of delay of 145 days in preferring the connected appeal. Full stop para. Let notice be issued, returnable on on 1st of July 2026. Sri
Jitado.
G.
Jitado.
Learned APP, except for one. Let steps be taken for service of notice upon respondents 2, 3, and 4 in the manner prescribed, which is to be routed through the office of the Learned PP Arunachal Pradesh. Full stop. On the next date, comma. By the next date, comma, the respondents may file their objections if so advised. Full stop. The Learned APP would also obtain the report on service of notice upon the respondent numbers 2, 3, and 4.
যাবো কেনেকে একটু লোকে যাবো কেনেকে
But Mr. APP, you have to see the description of the parties 2, 3, and 4.
Yes.
While trying to follow the law, this is not the way to follow the law. They have given nothing.
This is for condonation of.
Have you seen the description?
2, 3, 4
2, 3, and 4.
Description.
How will it go? So you, while taking steps through you need to put in the details. Case number is there. So the police station would have to serve.
Yes,
Through your, because see the description. You cannot have such a vague description, madam. It is correct that you do not disclose the name.
that
But
it's doctor of something
this will not even go. You have to take the necessary initiative.
Yes.
Let's see the description of 2, 3, and 4. Have you seen?
Yes. 2, 3.
And for how have they been described? Let's see.
Generally, it should go by name XYZ.
Thereafter,
Given address.
Address is also not there.
Yes.
You are
it's for the informant
you are
also.
supposed not to give the name of the victim, but everything has been made XYZ.
Address is.
Address at least you need to give. Address cannot be vague, madam. You cannot serve. But you have to take the initiative. On the record, from the record, you send it to the concerned police station, they will serve. Okay?
Obliged.
Item number 15.
Item?
15.
Lordship, this accusation convicted in 2022, Lordship. It is almost 4 years now. This IA is for condemnation of the delayed period in filing this appeal. This Lordship,
Conviction under which section of law?
this is a conviction is under this extortion section under
64
IPC section.
yes IPC section. Yes, 364. Life imprisonment laws.
Okay. Hard pursuance for learned counsel for the applicant who has filed this application under Section 5 of the Limitation Act 1963 for condemnation of delay of 1392 days in preferring the connected appeal. Full stop para, that notice be issued. Returnable on 1st of July 2026. Pursuant to learned APP accepts notice on behalf of respondent number 1. Let steps be taken for service of notice upon the respondent number 2 in the manner prescribed. Steps within 2 days. By the next date, comma, the respondents may file their objections, comma, if so advised.
Lordship, one more IA is also there pending
For?
this, under section 431 of DNSS, Lordship,
For?
for suspension of sentence, Lordship.
Without delay condemnation.
Yes.
How?
First, we have to condemn the delay, then we'll have the jurisdiction to pass orders.
That is
Now we do
clear.
not have any jurisdiction.
Okay.
Unless you make it an exceptional case, like a death sentence. Is it a death sentence?
No, Lordship.
So you're saved.
Lordship. All right.
Item number 16.
Yes, Lordship. Yes, Lordship. Yes, Lordship. In the meantime, Lordship, I will file my rejoinder, Lordship.
Okay, writ petition. Why? Before a DB? Rules are challenged.
Yes, challenge the RR, Lordship. Recruitment rule, Lordship.
Heard 3G Bam learned counsel for the petitioners. Also heard 3N Ratan learned AAG Arunachal Pradesh, who submits that affidavit in opposition has been filed. Para? The learned counsel for the petitioner submits that he would file rejoinder.
Yes, Lordship.
Puts the para. In view of the above, matter is adjourned to be listed on when? On 29th of on 30th of June?
Yes, Lordship.
30th of June. By which time, comma, further pleadings are to be exchanged.
Much obliged.
Are not are to be, may be exchanged.
Much obliged.
Item number 17 and 18.
Yes, 17 and 18, yes.
I, my lord, appear for the petitioner.
805. Yes.
Yes, sir. I'm appearing with Debasmita Ghosh. who's
Yes, yes, she's around. Yes.
around.
Why is it listed today?
My lord, today we will only confined to my lord, item number 17, IA, my lord. The implementer of my lord, Apsu, my lord.
IA is there.
For implement, my lord.
Implement.
Yes, all Arunachal Pradesh State Union, my lord.
So are you objecting to that?
I'm not objecting,
Yes,
my lord.
I am
The petition, they
objecting.
are object, my lord.
Who's the applicant in this?
I am the application for,
You want yourself to be implemented
yes.
and you are objecting, madam.
Yes, my lord.
Mr. Gonzalez, you are objecting to this.
Yes, my lord. I'm objecting.
Yes, you have filed your objection.
Yes, Lord.
And
If you-
I'm relying only on a judgment of the Supreme Court in the NHRC case, where the Supreme Court passed strictures against Apsu for committing crimes against the Chakma people. And my submission is, if you have such a background and the Supreme Court itself has passed strictures, you don't deserve to be made parties in these proceedings. That's my
No, but
argument.
that is a different matter. But if they are affected by the list, how can you prevent somebody not to participate?
They are not affected at all, my lord. I'm the only affected party. They are the assailants. They
Then I
are
have to hear
attacking the
it,
Chakmas, seeking
No, no,
deregistration.
Yes. So what is your what is the writ petition about?
My writ petition is, my lord, that I have been declared by 4 judgments of the courts, 2 of the Supreme Court, 1 of the Delhi High Court, and 1 of your lordship's court, the Guwahati High Court, that the Chakmas are entitled to be citizens of India. And as a corollary of that, if they are entitled to be citizens, they are entitled to all benefits and privileges. Now, my lord, for the last many years, they had what is called a residential proof certificate given from the 80s up to, my lord, very recently. So for 50 years, they had this proof. When they had this proof, my lord, they could go for government employment, they could go to the army, they can get employment. And this is for 50 years, and they serve in the army and so on. Then, my lord, Apsu comes on the scene and pressurizes the government to declare all these RPCs cancelled. So our limited prayer, or our main prayer, if you like, my lord, is that this cancellation orders be quashed and set aside, and the original situation of the RPCs be restored. That's the short point. Now, in the
But
meanwhile,
if the RPCs were cancelled on an initiative by a particular party,
yes, my lord.
wouldn't it be proper to give them a hearing?
Not this party, my lord. In view of the strictures passed against them, they have been campaigning for a very long time, and their name appears in the judgments of at least 2 judgments of the Supreme Court, criticizing them and passing strictures against them for threatening the lives of the Chakmas.
Mr. Gonzalez will not treat this to be having any relevance in this application for implement. If they make out a case that they are interested party where their opportunity of hearing is to be afforded, passing of strictures will not come into the way. That is for a different cause of action.
May I, my lord,
But
submit?
can that be the
Normally-
only reason of denying their attempt to enter into the proceedings? If otherwise we find that the cancellation was done at their initiative, to give them a hearing doesn't mean that we are agreeing with them. In the
May I
adjudication
submit, Lord?
process, they'll participate.
Yeah.
That is all.
This intervention and impleadment is part of a long history of intervening in this matter. They intervened to say we Chakma should be evicted. Same argument. We are not residents, etc., etc. We are outsiders, we are refugees, and so on.
Now, Mr. Gonzalez, simply by making that contention by them will not mean that we are going to accept without
No, I understand that.
application of our mind. Let them.
understand
Why should we debar them from making their views?
I'll tell you,
We
Lordship,
have
why.
it will be a complete adjudication. Tomorrow, if we decide in your favor, assuming you decide in your favor, they have a case that they have not been given a hearing.
I'll tell you, Lordship, why. Normally,
We hear and if you make out a case, we decide in your favor.
yes.
We hear
May I
them.
say, Lord? Normally, a party who is antagonistic will be made party. I understand that. I agree with that. But not a party that the Supreme Court has adjudicated has committed crimes against the Chakma people and directed the government.
Where is
And-
it?
And my lord,
Page,
I can finish, my lord, in a minute.
page,
And
the
directed the
strictures,
forces.
no strictures of the Supreme Court. Where is it? Page.
Yes, my lord. Now go to the judgment straight away, my lord.
Where have you stated in your opinion opposition?
This is the NHRC judgment, my lord.
No. Where have you stated in your objection?
Yes, my lord. Give me a second. I mentioned the judgment in the NA. Give me the application.
Hello, you made that commission.
The reply.
Very
And
complete.
my lord, if I can complete that thought. And in
Yes.
fact, the court has directed the forces, the police forces of Arunachal Pradesh to repel them by force. Repel APSU by force. Now, my lord, go to that is, my lord, my IA number 98, my reply in IA number 98. I filed it there, my lord. My affidavit in opposition to my lord, IA number 98 of 26.
Yes. Which paragraph?
And then paragraph 5, my lord.
Yes.
Paragraph 5.
Yes. We have just seen.
Paragraph 4 and 5, my lord. Paragraph 4, my lord, with regard to the averment made in so and so, so and so.
रेडी करके आया नहीं हम कभी नोट बना कर रखा था ये आपसे गायब है मैं
Yes.
Saying what? Yes, for paragraph 4 and 5. This is my averment, but I want to rely on the Supreme Court judgment directly, where the Supreme Court tells the police forces of Arunachal to repel them by force, repel them, when they were, my lord, engaging in crimes against the Chakma people. Such a party cannot be heard again, my lord. If you were a law-abiding party, you might be an opponent, no problem, then you would be made parties. But not if the court has itself said, not once but twice. Now, my lord, kindly see paragraph 4, my lord. Go to the
Yes.
middle of that paragraph, my lord. The applicant has no locus standi whatsoever to seek impleadment in the present proceedings. That is, has neither demonstrated nor established whether any legal or other rights are violated in the subject matter raised in the present instance, PIL. Further, the applicant does not suffer any legal injury, etc., etc. Now see paragraph 5, my lord. Paragraph 5, roughly 5 lines from the top of that paragraph.
Yes.
The true record of the applicant conducts as found by the highest court of this country, as reported in the case of NHRC versus State of Arunachal Pradesh, wherein the Honorable Supreme Court of India held that there is a direct threat to Chakmas and Hajongs, physical threat to people who were permanently settled and residing in the state of Arunachal Pradesh from the All Arunachal Pradesh Students Union and other organized groups who were trying to uproot them by force and forcibly drive them out of the neighboring state. Now, I've summarized it here, but I want to show you the judgment, and then your lordship will decide whether the person who engaged in criminal conduct, as said by the Supreme Court, can be made parties to be heard, or I'm also an affected party, I want to be heard. And what is that affected party? Namely, that these are foreigners. I want to tell the court, they are saying that they are foreigners, something which is repelled by the court in 4 cases. Now, my lord, go straight to the judgment. In the compilation of judgments, go straight to the NHRC case.
Yes.
Then your lordship will decide with these observations whether such a party ought to be heard in any proceedings regarding eviction of Chakmas and disentitlement of Chakmas. It starts, my lord, your lordship has that?
Yes, yes.
HRC versus State of Arunachal. It's at page 31, my lord.
Page 31 of what?
Of the compilation, my lord.
Yeah, just give us a minute. Just give us a minute.
Yes, my lord. That's, my lord, National Human Rights Commission versus State of Arunachal Pradesh. Didn't number the pages. There, yes. There, yes.
Reply copy they have not given us.
उनको ये कहाँ से मिला? ये नहीं। Objection में copy ना लगा दो हमारे।
Here, my lord, they say this APSU's actions and its plan and so on should be repelled by the paramilitary forces. Terrible, my lord. It was really, the Supreme Court took great offense at what they were doing. It's like a criminal background for these people. Page 37, my lord. I'm sorry, my lord, I think I didn't number the pages or something. National Human Rights Commission versus State of Arunachal Pradesh.
Yes.
Yes, my lord, paragraph 14 of that judgment.
Paragraph 14,
Yes, my lord. And my lord,
page
kindly
37.
37.
paragraph 14 of
Yes.
that internal page 748. Lordship has that?
Yes, it is further.
Yes, my lord. And kindly keep in mind, my lord, State of Arunachal Pradesh and the Union take a common stand. Now I'm reading that, my lord. It is further submitted by the first respondent, that's the state, that under the Constitution, the state of Arunachal Pradesh enjoys a special status, and bearing in mind its ethnicity, it has been declared that it would be administered under Part 10 of the Constitution. That is the reason why laws and regulations applicable during the British regime continue to apply even today. Now, this is their objection, both of the Union and the state. The settlement of Chakmas in large numbers in the state would today, one second, Malok. The settlement of Chakmas in large numbers in the state would disturb its ethnic balance and destroy its culture and identity. The special provisions made in the constitution would be set at naught if the state's tribal population is allowed to be invaded by people from outside. The tribal population, the tribals therefore consider Chakmas as a potential threat to their tradition and culture, and are therefore keen that the latter do not entrench themselves in the state. Besides, the financial resources of the state without central assistance, which is ordinarily not forthcoming, would throw a heavy burden on the state which it would find well nigh impossible to bear. In the circumstances, contends the first respondent, it is unfair and unconstitutional to throw the burden of such a large number of Chakmas on the state. And this is their reason for impleadment as well. Rejected 4 times by 4 courts, including the Guwahati High Court, we are unable to accept the contention of the first respondent that no threat exists to the life and liberty of the Chakmas, guaranteed by Article 21 of the Constitution, and that it has taken adequate steps to ensure the protection of Chakmas. After handling the present matter for more than a year, the NHRC recorded a prima facie finding that in the service of quit notices given by the Union, my lord, the impleading party, and their admitted enforcement appearances seem to be supported by officers of the first respondent. The NHRC further held that the first respondent had, on the one hand, delayed the disposal of the matter by not furnishing the required response, and had, on the other hand, sought to enforce the eviction of Chakmas through its agencies. It is to be noted that at no time the first respondent sought to condemn the activities of APSU. However, the most damning fact against the first respondent are to be found in the counter affidavit of the second respondent. In the assessment of the Union of India, the threat posed by APSU was grave enough to warrant the placing of 2 additional battalions of CRPF at the disposal of the state administration. Whether it was done at the behest of the state government or by the Union or its own is of no consequence. The fact that it had become necessary speaks for itself. The second respondent further notes that after the expiry of the deadline of 94, the APSU and other tribal organizations continued to agitate and press for the expulsion of all foreigners, including the Chakma. It was reported that APSU had started enforcing an economic blockade on the refugee camps, which adversely affected the supply of rations, medical and essential facilities to the Chakma. Of course, the state government has denied the allegations, but the independent inquiry of the NHRC shows otherwise. The fact that Chakmas were dying, criminal conduct of this group, my lord, a criminal party will not be allowed to implead, my lord, I hope. The fact that Chakmas were dying on account of the blockade for want of medicines and is an established fact. After reports regarding lack of medical facilities and the spread of malaria and dysentery in Chakma settlements were received, the Union of India advised the first respondent to ensure normal supply of essential commodities to the Chakma settlement. On 1995, the APSU once again issued an ultimatum citing 31/12/95 as the fresh deadline for the ousting of Chakmas. This is yet another threat which the respondent has not indicated how it proposes to counter. Now, my lord, go to paragraph 18, kindly, my lord.
Yes, 18.
Yes, my lord. This is after rejecting all the viewpoint, my lord, of the state and APSU, rejecting their viewpoint that these are outsiders, these are foreigners, they cannot be settled. 4 times that argument is rejected. Paragraph 18.
Yes, please.
From what we have said herein before, there is no doubt that the Chakmas who migrated from East Pakistan, now Bangladesh, in 1964, first settled down in the state of Assam and then shifted to areas which now fall within the state of Arunachal Pradesh. They have settled there since the last about 2.5 decades, raised their families in the state. Their children were married and they too had children. Thus, a large number of them were born in the state itself. Now it is proposed to uproot them by force. The APSU has been giving out threats to forcibly drive them out of the neighborhood, which in turn is unwilling to accept them. The residents of the neighboring states have also threatened to kill them if they try to enter their state. Thus, they are sandwiched between 2 forces, each pushing in opposite direction, which can only hurt them. Faced with the prospect of annihilation, that is how serious the attack was. The NHRC was moved, which finding...
Mr. Gonzalez, we are just interfering. These arguments can be made at the time of final hearing for the relief we are claiming, that cancellation of residential certificate is in the teeth of the observations made by the Honorable Supreme Court.
So
but at the time of adjudication of an application,
yes,
praying for implement,
yes,
your scope would be very limited. We are very liberal in giving an opportunity of hearing. Doesn't mean that we are agreeing with them. We will only give them a hearing.
My lord, my answer is very simple.
Because one more line.
Simple.
Because this entire process has been initiated on a representation 18/7/2022 filed by the present applicant who is seeking implement.
Yes.
If at the time of adjudication we do not give them a hearing, the process would not be a fair process.
Yes, I want your lordship to say this.
Yes, sir, you can place all these. This will be relevant consideration.
May I just say
that the strict observation of the Supreme Court would be relevant consideration for us on the merits of the case.
May I say,
on the merits? Yes,
I understand what your lordship is saying.
Yes.
I want to frame the issue. And I want to give 3 paragraphs at the end to finish this.
Yes.
I'll make my point straight away.
Yes.
Would your lordship allow a party which has criminal conduct writ large in the judgments of the court?
That is not a relevant consideration in implement. We are making it very clear.
See, my lord, when a petitioner
very
comes-
clear. That is not a relevant consideration for an implement application.
See, may I
It may be a relevant consideration at the time of final disposal.
My lord, I'll just make my point, my lord.
We are
When
making our
petition-
process very transparent and clear. We want to give a party an opportunity if they make out any case that they have an interest in the lease. And this entire lease, the dispute has arisen from a representation filed by this applicant on 18/7/2022.
So I'll
We are
just
sticking
I'll
on
answer
that.
your lordship's query to the best of my ability.
Yes.
When a petitioner comes to the court, a petitioner may have some very good arguments to make in law and so on. But if his background and conduct is criminal, and it is recorded as criminal conduct, your lordship will not hear the party he may have very good arguments to make, but he will not be heard. Now,
Then
my
we do not hear any
argument-
accused. Mr. Gonzalez, in this case, we don't hear any accused. Condemn them without hearing.
Yes, but
If we
this-
allow if
Yes,
you
Lord.
if
So
you
my-
accept your argument, all accused are not to be heard. Give them an opportunity of hearing. What is the
No, my lord,
why are you
those who are-
shying away from facing them in the proceedings?
May I just say, my lord, I want to finish my argument on this, and
Yes,
we
yes.
got 2 more paragraphs, and I'll stop, my lord.
No, would in fact love to hear you on the actual petition.
I thought today was
on
that
the
day, my
April-
lord. I
Not
thought today
on the- on
because
the-
they were-
No, on the application we are hearing. We are not hearing the main writ petition. Main writ petition, these are really very relevant submissions. whether we accept or not, but this is a very relevant submission.
So, my lord, I just
Definitely have
finished,
to
my
apply
lord.
our mind.
I'll finish
But
in the
I
next
think
short while. I won't trouble you. with
implement,
that.
you did not oppose so strenuously, implement. We'll record your, obviously your submissions, but implement, as you know, we are not
Yes,
that
Lord. So
strict.
I'll make my last submission in answer to your
Yes,
lordship's
please.
query, and then
Yes.
I'll read out 3 paragraphs to continue and finish.
Please do.
A
Yes.
party whose conduct has been criminal and castigated by the Supreme Court is not a party to be made party in any proceedings that is a discretionary order of your lordship's court. They are not affected in any way, or if they are affected because they say that outsiders are being accommodated, that argument has been heard and rejected 4 times. So criminal conduct will exclude a party from being made a party in this case. I'm specifically making that.
Okay.
Yes. Now, to bring home that point, I want to read 3 paragraphs of the same judgment your lordship was reading. Para 21. Para 21.
At
See
page 41.
Para
Page 41.
21.
Page 41.
Para 21, page 41. Yes, my lord.
Yes.
In view of the above, we allow this petition and direct the first and second respondent by way of a writ of mandamus as under. The first respondent, the state of Arunachal Pradesh, shall ensure that the life and liberty of each and every Chakma residing within the state shall be, and any attempt to forcibly evict or drive them out of the state by organized groups such as APSU shall be repelled, if necessary, by requisitioning the service of the paramilitary or police force, and if additional forces are considered necessary to carry out this direction. Then, my lord, subpara 3. The quit notices and ultimatums issued by APSU and any other group tantamount to threat to the life and liberty of each and every should be dealt with. Now, my lord, this is my argument. A group that has threatened the life of the petitioner will be allowed to implead and carry on with its same program of forcibly trying to evict. I can understand if they came to court and say, from today onwards, sir, there will be no taking the law into our own hands. There'll be no violence against Chakma. There'll be no blockades and dharnas and strikes against Chakmas. We will go only by the rule of law, and we will go only to the court, and we will not engage.
So, Mr. Gonzalez, for that, an undertaking is not required. They are bound in law. Why should they give an undertaking that I'll abide by the law?
Yes,
They're bound in law to abide by the law.
Yes, well, I got what your lordship is saying. I'm only saying a party with criminal conduct
Yes,
has
so that
not
we
renounced its
that
criminal.
we will consider.
Yes, well, yes, I'm grateful. And if your lordship could kindly keep, would your lordship hear the matter today? I'm fully ready with the documents.
Today it may not be possible. If we allow this petition, then we'll have to give them a chance to file their response. We'd like to hear the counsel. In fact, he is yet to be heard. There is a counsel for the applicant. We'd like to hear him. What is his interest in this list? Yes. What is your name?
Nabam Jalo.
N. Jolo. You're for the applicant. Yes. What is your interest in the litigation? This is a litigation filed by a group of persons being aggrieved by cancellation of their residential status. How are you aggrieved? What is your interest in this list?
Since APSU is spearheading this movement for last 6.5 decades to protect the preserve the cultural identity and integrity of the ethnic group of Arunachal Pradesh. And APSU is not confined only to the students and university, college, and its movement to protect the people of Arunachal Pradesh. And really, as Learned Council has already pointed out, that protest movement, we have not done any crime against the Chakma people of Arunachal, in spite of they have been settled in Arunachal Pradesh for last many years, and we are appealing the government of Arunachal Pradesh and the Union Government of India to resettle and relocate these people, and they have been settled in Arunachal Pradesh on humanitarian ground, not by the people of Arunachal. During the settlement of this Chakmas, where the government of India has not consulted the people of Arunachal Pradesh. The local people are leaders of the state who are not consulted. They have settled this Chakma and they haven't settled in Arunachal.
So how do you respond to the learned senior counsel for the petitioner, opposite party, who has argued and rather shown placed before this court the very serious concern of the Honorable Supreme Court so far as your conduct is concerned? Your conduct has been condemned.
They have
And,
missed
the
this,
direction
my
is to
lord.
use force to repel your criminal nature conduct, kind of a conduct. How do you respond to that? That is what has been placed by the London Senior Council. How do you respond to that?
Will file may allow the record and the brief Karam of this honorable court will produce a relevant document in time of hearing and will file control affidavit regarding this allegations.
No, that is only after if we allow your implement application.
Yeah.
But here this trust is that a person who has a criminal background and these have been taken cognizance by the highest court of the land and have condemned. Do you have a right to get a hearing in a list of this nature where the residence status challenge cancellation is put to challenge?
Whether they will able to produce FIR, and we have the Chakma, there is a number of criminal cases again recorded in the state of Arunachal Pradesh, and criminal, civil, and forest deforestation of the state, and in the relevant time will produce this document. I will file and reply and the counter affidavit. So,
Yeah, you have anything to say, Mr. Nabam? Are you a party here? You are a party.
My lord, yes, my lord. My lord, basically, in this petition, they are agreed, my lord. Forget about, my lord, they are resettlement, settlement, all these things. They are agreed basically against the, my lord, TRC, that is temporary residence certificate, my lord. Now, my lord, your lordship is ever, my lord, we cannot issue them PRC, that's a permanent certificate, my lord. My lord, we are, my lord, guarded by, my lord, special act, my lord. Now, my lord, we issued this TRC certificate so that, my lord, they get facilities to academic and employment, my lord. Then there was an advertisement issued by the, my lord, MHA, my lord, for recruitment in Assam Raipur, my lord. They applied, enclosing, my lord, TRC certificate, and that was not accepted. That is the main grievances in this PL, my lord. My lord.
No, the grievance in the PIL is what? The grievance is against cancellation.
Cancellation, my lord. My lord,
Cancellation.
my lord, cancellation, my lord, as I've said, my lord. Now, PRC can be issued to the indigenous local person only.
No, those will decide in the list.
My
Those
lord.
will decide.
My lord.
Those petitioner would like to advance their arguments. You would like to advance your arguments.
My lord.
Whatever we think is proper, we'll decide. That is a different matter.
My lord. My lord, so far, my lord.
Okay.
My lord, so far PRC is concerned, my lord. My lord, just 2 minutes, my lord. My lord. The same issue was, my lord, raised in my PL 20 also, my lord. The coordinate bench held, my lord, yes, my lord. They cannot participate in the local panchayat election. The local panchayat, when you say, is for the local, my lord, indigenous person, my lord.
You place those in the
Yes.
hearing? Okay.
May I, my lord, say only 1 minute more? 1 minute.
Yes, Mr. Gonzalez.
Additional argument. The
Yes.
state is there to represent the people of Arunachal who are non-Chakma as well. So the non-Chakmas, I mean, the people of Arunachal, if they are affected in any way, the state will represent. Here we want additional person to come in and represent their interests, not necessarily.
I'm sorry, Mr. Lord, senior counsel, is it
Is it
mean
so
that,
the-
my lord, any,
so
my
the
lord, like,
question-
my lord,
One
ASU
second,
is
sir,
not
one
sparing
second.
heading, my lord.
One
Can
second.
any authority declare as it is unauthorized or illegal, something like
Okay,
that?
we'll consider.
I think there is not.
One
there, my
second,
lord.
sir.
I'm sorry.
May
my
I
lord.
just
Yes.
finish in a minute, my lord?
Yes, yes, please
Therefore,
do.
if we ask the question, are you necessary, without which we cannot decide the list? Not necessary. State is there. So you're not necessary. Then are you
Okay.
proper? That's when my criminal conduct argument comes. So neither necessary nor proper. Grateful, my lord.
Okay. Okay. Please wait, huh? What did you say? Anjolo? Anjolo Learned Council. For the applicant who, for the applicant also heard Sri Gonzalez Learned Senior Counsel who has appeared online, assisted by Ms. D. Ghosh, who is physically present. The instant application has been filed praying for implement in the connected PIL as respondent number, what? 6. Respondent number?
Number 6.
6. Para. Sri Jolo, the learned counsel for the applicant, has submitted that the subject matter of the writ petition emanates from certain complaints, including representation dated 18/7/2022 on the aspect of grant of residential status or status of certificate.
My lord, it's a certificate, my lord.
Residence certificate to the people of the Chakma community, which led to passing of the impugned order, which are the subject matter of challenge in the connected PIL 19 of 2025. The learned counsel has submitted that in the said PIL, the applicant has not been made a party respondent. Full stop. It is submitted that the applicant is a necessary party, as it is at their instance that the impugned order has been passed, which is the subject matter of challenge. Para. Per contra, comma, Sri Gonzalez, the learned senior counsel, has strenuously objected to the application for implement. He has fairly submitted that though usually such objection is not there in an implement application, comma, in the instant case, there are serious observations made by the Honorable Supreme Court in a number of cases against the applicant on their conduct. Full stop. He has specifically referred to the orders, to the observations made by the Honorable Supreme Court in the case of so-and-so, reported in 1996, 1 SCC 742, and the relevant observations made in paragraph 14 and 15 are pressed into service. 14, 15, and 21 are pressed into service. He has submitted that a party whose conduct is inherently criminal in nature should be excluded from an adjudication process. He has additionally submitted that the list which is in connection with a challenge to the cancellation of the residential certificate would be contested by the state and would represent all the affected communities. He has submitted that the application for implement is misconceived, as the applicant is neither a necessary party nor a proper party, and therefore is liable to be dismissed. Full stop. Para. The rival submissions advanced by the learned counsel for the parties have been duly considered. Full stop. Para. As observed above, comma, an application for implement is liberally considered usually. Full stop. In the instant case, the only requirement of an applicant seeking implement is to show that such applicant has an interest in the list, the result of which would also affect them. Full stop. In the instant case, comma, it is not in dispute that there is a representation dated 18/7/2022 by the applicant, which had culminated in the impugned orders. There is a specific averment in paragraph 13 of the writ petition of the PIL, which read as follows. Page 16, paragraph 13, quote of the PIL. While the learned senior counsel for the opposite party, writ petitioner, has strenuously argued that the applicant has been that serious observations have been made by the Honorable Supreme Court questioning their conduct, we are of the opinion that the said aspect may be a consideration in the final adjudication of this matter and cannot come into the way of the present applicant seeking their implement in the list before us. As mentioned above, it is because of the initiative of the applicant that the impugned order has been passed, which is the subject matter of challenge in the PIL. Full stop. In view of the above, we are unable to accept the objections raised on behalf of the opposite party writ petitioner towards implement of the applicant. Full stop. Accordingly, the IA stands allowed, and the applicant so-and-so is implemented as respondent number 6. Full stop. Consequently, the respondent number 6 would be at liberty to file the response to the PIL, for which this court grants 3 weeks' time. Full stop. Please give us a date of your convenience. Madam Ghosh.
Vacation, Lordship.
Before vacation. Mr. Gonzalez, any date you'd like to prefer?
Sir, any date except
Because
first week of July.
I think you'd also like to file your response to their objection. I think your rejoinder will be necessary. So let them file their opinion opposition within their counter affidavit within 3 weeks. We fix it on 1st of July. 1st of July is okay?
Sir, just keep it after 5th, sir. If your
After
lordship.
5th, we'll have the vacations after 5th.
Oh,
Then
sir,
20
before
We can have it
first,
on-
sir.
We can have it on
Before
21st. Before 1st, we can have it on the 30th. Because probably 30th, you'll need to be given time to file your
Yes, sir.
rejoinder
Yes.
on 30th. You file, Mr. Jolo,
Yeah.
file it before 30th and serve copies in advance. Okay.
So that we also, if required, within the meanwhile, we will file our
Yes, yes.
Sir, kindly keep it on 30th for arguments. I'll be ready.
Okay, for 30th.
If he serves us.
Okay, don't say anything, so on 30th, okay.
Yes.
Okay, 30th. Because
Grateful.
it's good to hear Mr. Gonzalez after a long time.
Yes, my lord. Sorry I took up so much time, my lord.
No, not at all. It was a pleasure to hear it. Yes.
Grateful.
Item number 19.
19 years.
My lord, this has been prepared by the Union of India.
What do you want in the IA?
My lord, the IA is for condemnation basically for
How many days?
167 days, my lord.
Regarding what? A scat order?
No, my lord, but the order passed by this honorable court
Oh, it's a
whereby
writ appeal.
writ appeal, my lord. So therefore only this is the official procedure where, my lord, just this has been taken, my lord. So therefore,
167 days
yes, my lord.
by the Union of India.
My lord.
Why should we be so liberal?
My lord,
with
at
the
that
Union
point
of
of
India?
time, as per the my lord, department made in the IA, my lord, they said, my lord, that they were very busy in the parliament session, my lord.
Very busy.
Very busy, my lord. The official were,
So very busy, so we dismiss your application.
my lord.
We are busy with many other matters.
My lord, if my lord enters the merit of the case, my lord, it's a very good case for the Union of India, my lord. Just to, my lord, my lord,
Sri M. Kato Leonard, Deputy SGI, appearing for the applicant who has, by which condemnation of delay of 167 days
my lord.
has been sought for. Whereas the learned counsel, learned Deputy SGI has submitted that there are good grounds of appeal. Let notice be issued, returnable on 1st of July
My lord.
2020.
My lord.
6. Let steps, Madam Pangu, for 1.
For 1 to
1, 2,
6,
3,
your lordship.
4, 5, and 6.
Yes, your lordship.
Airport authority, is anybody appearing? Does anybody appear?
Yes, my lord. Mr. Dubey was appearing, my lord.
No, then you have to send it.
My lord.
6 extra copies. 7, 8, and 9 by speed post with ED. Steps within 2 days. By the next date, come objections, if any, be filed.
Unless, your lordship.
Item number 20.
20. Hearing.
My lord, this item number 20, my lord, I have to take instruction because my lord, the amendment of recruitment rule was initiated, my lord. If that is notified, my lord, perhaps, my lord, the petition will become infractious, my lord. Because what they wanted, my lord, we have already initiated, my lord. Now that status, my lord, I have to take instruction, my lord.
My lord,
Senior counsel for
my
the
lord,
applicants, for the petition.
my lord, only predicament with my client is that, Lord,
It's taking little bit
22nd
longer
of
time.
September 2022, they have filed their affidavit in opposition, wherein they have categorically stated that within 15 days they are going to frame the rules. Now, much water has flown in beneath the bridge for 4 years. And the extent,
Because of the rain, more water has flown.
My lord, I'm sorry, my lord, 15 days.
Much more water. has
yes, categorically in their.
There must be
And
something wrong. Otherwise, my lord, 15 days, my lord, it is not possible to amend any recruitment.
flown. Possible, but
Not
from
possible.
September to June, I think it's
22. September 22, my lord.
22.
Yes, ma'am.
Mr.
4 years.
That's why, my lord, I need to take instruction, my lord, now, my lord.
22. We're in 2026.
Sir, affidavit portion nyawa.
Affidavit.
Affidavit last place.
We'll grant the last opportunity.
My lord, very well.
Otherwise, we'll hear this matter.
Finding the date.
And I have noted that 22nd September. They were.
Sri T.T. Taralan, Senior Counsel, assisted by Sri G. Bam for the petitioners. Full stop. Also heard Sri R.H. Nabam, the learned AAG. Para? The learned AAG has submitted that there are initiatives and moves for amendment of the concerned recruitment rules, which would which should be in the line of redressal of the grievance of the petitioners. Full stop. Para? Sri Tara, the learned senior counsel, has, however, informed this court that such a submission was made way back in September 2022.
Proposal initiation.
And sufficient time has passed.
It's a proposal.
In the interest of justice and as a last opportunity, a month's time is granted to enable the learned AAG to obtain necessary instructions on the development, on the development, on the progress achieved and the status. Better? On request, accordingly, matter is adjourned to be listed on
23rd July.
23rd of July. You get enough time.
My lord.
Grateful.
Instruction clear.
Item number 24 and 25.
Met to your lordship.
Yes.
No, there are two matters, 24 and 25. 24 is the writ appeal against the judgment passed by honorable single judge. And 25 is the writ petition where the rules are challenged by my learned friend, Mr. Tony Partin, my lord.
Yeah.
My lord, so far as I am concerned, today I am not keeping well, I couldn't go. But even otherwise, possibly, my lord, if the writ petition is decided and if it is allowed, then there will be no requirement of hearing this writ appeal. Only in the event the writ petition is dismissed, my lord, there will be requirement of hearing the appeal. So may I pray, my lord, my lord?
We don't want to deprive ourselves from hearing learned counsel, Mr. Mazumdar.
My lord, it would have been my pleasure to go there and argue before lordship. But today somehow I am not keeping well.
We'd wish Mr. Mazumdar to be fit and come back on a day when we'd like to hear Mr. Mazumdar as well as Mr. Partin.
My
So
lord,
you
so,
suggested it when you can be fit.
well, I'll leave it to my friend, Mr. Partnin, to address the court
But let
because
In that case, but let it be on Wednesday, next Wednesday.
Wednesday, DB will not be there. Thursday.
my lord, next week I am not. Next week, my lord, I've got some personal difficulty, not professional, personal difficulty. I'll be out of station.
Then we can have it on 23rd.
Yes, madam. That-
23rd is okay for you, Tuesday, it's a DB day.
My lord, 23rd, I've got a PIL in Guwahati to represent the state, my lord.
Then on
Can
the
it be on 25th? 25th is a 25th is a Thursday, my lord.
You'll be arguing online. So it's just another case for you.
My lord, can it be on 25th, my lord? 25th.
25th. Okay, 25th, okay.
My lord.
D. Mazumdar, Learned Senior Counsel, appearing online. And Sri T. Patil, Learned Counsel for the Mazumdar is for the writ appeal.
My lord.
So,
Yes.
Mazumdar for writ appeal 53 AP and Sri T. Patil, Learned Counsel for the petitioner in
25.
Yeah, that is a writ petition in.
Yes.
Yes.
That's a writ petition, madam.
1 of 2025. Also heard Sri D. Also heard Sri N. Ratan, Learned AG, and Sri D. Panging, Learned Senior Counsel for the respondent prior respondent.
Private respondents.
Para? Jointly agreed by the Learned Counsel for the parties. Matter is adjourned to be listed for hearing on 25th
Fifth.
of
My lord.
June.
My lord.
Okay.
Obliged.
Deeply obliged.
Okay, single bench will sit with. Yes,
Lordship, I beg to mention item number 13.
1-3.
Yes, we are supposed to take instruction from the client whether they want to pursue this or not. So, Lordship, 2 weeks time may be given.
What is your name?
S. Irang, Lordship.
Item 13.
Yes.
Huh? 14.
14, Lordship.
Oh, don't mention somebody else's case. And that too for Joel.
Yes, Lordship.
14.
Yes.
Your S. Yarang.
Yes.
Sri S. Yarang, Learned Counsel for the petitioners
Yes.
has submitted that instructions are required to be taken as to whether the writ petition would be pursued or not. Para? Also heard Ms. Wang Mu, the Learned State Counsel. Para? In view of the above, matter is adjourned by a week to enable
Yes, Lordship.
the Learned Counsel for the petitioners to take necessary instructions. List on
Lordship, after 2 weeks, Lordship.
2 weeks. Why
Yes.
2 weeks? 2 weeks, then say 2 weeks. Huh? List on today's 4th. We'll have it on 22nd. 22/6. More than 2 weeks you get it. Okay.
Deeply blessed.
May it please your lordship, I beg to state item number 17.
17.
Yes, your lordship, for the petitioner. Due to learned counsel's father's serious illness and his own
Who?
M. Bagra, your lordship.
Okay. Have you informed Mr. Kato?
Yes, lordship.
Okay, somebody is
Yes,
not
sir.
well. Okay. A request for adjournment has been made on behalf of Sri M. Bagra, Learned Counsel, who has serious medical emergencies at his home. Full stop. Also heard Sri M. Kato, Learned Deputy HGI, who has not raised serious objections, who has not objected to the prayer for adjournment.
Right.
In view of the above, list on when? List after 2 weeks?
2 weeks, yes, your
2 weeks same date, huh? Last part same. Will be on 22nd, bola tha kya? 22, same 22/6. Yes, madam.
My lord, I beg to mention an unlisted item, my lord,
Unlisted, when? For when?
for as last matter.
Today?
Yes, my lord.
Motion?
Yes, my lord.
Can you bring it?
We are filing it now, my lord.
What is the urgency?
My lord, masjid demolition. Tomorrow, the organization is demanding for demolition of masjid, my lord.
of the demolition.
Yes.
We'll file it tomorrow, move it tomorrow morning.
My lord, there will be ban call tomorrow.
Will be available online.
My lord, if possible, please take up the matter at the end of the.
What documents do you have that there will be demolition? Who demolish? Law and order is there. Law and order will protect you.
My lord, if there is no court order, my lord, we may not be able to protect.
We cannot assure. You try to bring, but if the matters are over, we'll not be able to do it.
Yes,
And you have to move it tomorrow.
Yes, my
We'll
lord.
allow you to move it online. Okay?
Yes, my lord.
Okay. Yes.
Item number 1.
Contempt petition, my lord.
Contempt.
Yes, my lord.
First time.
Yes, my lord. This arises from
Which
willful
order?
order dated 5/6/2025 in WPC 624 of 2023, whereby, my lord, this honorable court set aside the cancellation order dated 6/11/2023, my lord. My lord will find the order in page number 10, my lord.
Order of the court is 5/6/2025.
Yes, my lord. Yes, my lord.
When did you file this? 3/6.
Yes.
How much time was granted? Was there any?
7 days time, my lord.
Let us see the operative portion.
In page number 14, my lord.
14.
Yes, my lord. May I read, my lord? It is further provided that as and when the petitioner comes within the zone of consideration for,
You have not been reinstated.
no, my lord.
Till now, not reinstated.
No, my lord.
Okay. Heard. Miss
M. Karbak.
Where is your name, madam? M. Karbak.
Yes, my lord.
M. Karbak, learned counsel for the petitioner, who by means of this petition has complained of willful and deliberate disobedience of an order dated 5/6/2025 passed in so and so. Full stop. It is submitted that apart from other directions, there was a direction to reinstate the petitioner in service, in contractual service, which has not been done till date. That notice be issued, returnable on 1st of July 2026. Don't say that. Let steps be taken for service of notice upon the respondent by speed post with daily steps within 2 working days. Yes,
Item number 2 and 3 also, my lord.
same
Same order.
order.
Yes, my lord. But
Same-
different petitioners.
Understood,
Oh.
but the direction is the same to reinstate
Yes,
them.
yes,
Okay,
madam.
same order, okay? Check the order, it is same.
Yes, same, my lord.
Writ petitions are different.
Yes.
In WPC, all of it. Take steps by speed post to daily.
Yes.
Respondents are also the same.
Yes, my lord.
Okay. Number 4.
Obliged.
Item number 4.
May it please your lordship. Your lordship, this matter is pertaining to rustication from school. And the petitioners herein are, your lordship, minor cadets studying in Sainik School, Niklok, East Siang district. And being minor, your lordship, the petitioners are being represented by their respective parents.
Okay. You are challenging your restriction.
Yes, your lordship.
What are your grounds of challenge?
Your lordship,
They have the power to restricate.
firstly, your lordship, the rustication order has been passed without issuing any show cause notice, lordship. Without giving any opportunity.
Is it required?
Yes, your lordship, because since your lordship, the apart from the investigation, your lordship, the charges has already been filed, and the case is already pending, your lordship.
There's a criminal case.
Yes, your lordship. Now, the admission process has already been started.
Mr. Kato,
This is
is any show cause required for restriction?
hopefully.
More so when there is a criminal case.
Yes, madam.
Okay, we issue notice.
My lord.
What is your name?
Your Lordship, I have specific prayer, Your Lordship, regarding that since the admission process has already been started, Your Lordship. Now, some schools, they have already, in some schools, the admission process has already been completed. And during this notice period, Your Lordship, if tomorrow this writ petition is, the petitioner does not succeed from this writ petition, Your Lordship, then it will jeopardize, Your Lordship, the situation of the one academic year will be lost, Your Lordship. So
You are restricted in, what is the stage? Which class do you read?
class 10, Your Lordship. We have passed class 10 on the last board exams, Your Lordship.
Now you
So
will-
seeking admission to class 11.
You will be taking admission in 11.
Yes, Your Lordship. Now the situation is that no admission has been granted.
Take instructions.
My lord.
He's pressing for an interim direction. We can have this on Wednesday next,
Well,
as soon as possible, because
my lord, I'll come with the instruction.
if the period of admission is over, and if he succeeds tomorrow, then it'll be almost infructuous. If he doesn't succeed, matter is different.
Sure.
We'll have it on Wednesday.
Yes.
Okay. What is your name?
D. Tatak, Your Lordship.
D.
Tatak.
Third Street D. Tatak, Learned Counsel for the petitioners who are aggrieved by their rustication from the respondent school. Full stop. It is submitted. He has also pressed for some interim directions. Para. In view of the above, let instructions be obtained by Sri M. Kato, Learned Deputy GI. And the matter will be listed for motion on Wednesday next.
My lord.
Obliged, Your Lordship.
Deep down.
Lordship, I'm not getting the file of 5. So I should, item 5 is not here. So shall I call item 6?
5 is not there.
Some advocate has taken, so that.
Who has taken the records of 5? Why do you allow the records to be taken?
Some advocate was, he asked for the file and he was looking here and he didn't give return back.
How is this possible? You cannot take out a file from the court.
And
who's the advocate in 5? And Talin, you are Talin.
Yeah, no, answer.
Answer, you're for
Yes,
the
petitioner.
Somebody had taken the file.
Shall I come now?
You,
Your senior.
Mr. You're Saha and Saha.
Yes, Lordship.
Wait for a while.
Yeah, okay.
Let the file be read. We'll take the next matter.
Item number 6 to 10.
6 to
May
10.
it please, your Lordship. May it
Mr.
please, your
Chaudhary,
Lordship.
yes.
Yes, I'm appealing for the petitioners, my lord. My lord,
Yes.
in fact, on last occasion, we agreed that once the state government files the affidavit, otherwise pleadings from the other respondents are over, are completed. So we agree for a hearing date on 29th of June, my lord. I have spoken to subject to Lordship's convenience.
But state has filed affidavit. State has filed affidavit.
I had this morning. Yes.
Not yet
No,
filed by the
state government has not.
No, you will file affidavit or not, Madam Wangmo? Senior counsel is saying that after the state responds to the writ petition, it can be taken up for hearing on 29th of June. We do not have any difficulty, provided you file the affidavit.
Yes. Yes,
Mr.
yes.
Gaming, madam.
Let them file their affidavit in the meantime, my lord.
Can you file it in the, okay. Hart Street, K.N. Chaudhary, Learned Senior Counsel appearing online, assisted by Madam, your name?
I'm sorry.
M. Sora, who is physically present. Also heard Ms. Pangu, the Learned State Counsel, and Sri M. Kato, the Learned Deputy SGI. Full stop. The Learned Senior Counsel for the petitioners likhiya, number of cases, has informed that pleadings have been exchanged and only the state is required to file their affidavit. Para, Ms. Pangu, the Learned State Counsel, has submitted that affidavit would be filed within a period of 2 weeks. Full stop. Para, as agreed to by the Learned Counsel for the parties, placed for the admission hearing on 29 6/2026.
Yes,
Your
sir.
Honor,
Interim orders will continue. Interim orders.
Okay, interim order passed earlier to continue till the next date of listing. Okay.
Deep level.
Item number 11.
Or just a minute. Oh, this, Mr. Chaudhary. Mr. Chaudhary, I'm sorry, this matters, this court will not like to take up. Your matters, future gaming,
Oh.
just saw the names. But future
But this is
gaming
a
and
GST.
hotels,
This is a GST matter, nothing to do with lottery. Of course, arising out of lottery. Anyway, I leave it to your lordship, Miller.
no, not by us, not by us. Leave this for any other. This is for any other bench. Have it on Monday. Monday you can have the same order, perhaps.
Yes. We'll do that.
And on request, list on Monday.
Yes. Deep level.
Item number 11.
May Your Lordship, we have filed, and for the petition, we have filed the rejoinder, Your Lordship.
11, you are for the petitioner.
Yes, sir.
What is your prayer?
In respect of affidavit filed by the respondent 4 and 5, Your Honor.
You'll be filing rejoinder.
We have filed today.
You have filed rejoinder. Who is for 4 and 5?
Madam, for the state respondents, I am appearing.
4 and 5.
Yes, madam.
You have 4 and 5.
Your Lordship, I am appearing for union respondent number 1.
Now, who is 4 and 5? State?
4 and 5, yes, state.
You have filed response.
Yes, we have
Rejoinder.
filed our
So you
affidavit.
can have it for admission hearing.
Yes.
You have filed it today, madam.
Yes, Your Honor. Kindly matter will be fixed on 8, Your Honor. Monday, Your Honor.
Okay. Your M. Sora.
Yes, Your Honor.
Heard Miss M. Sora, learned counsel for the petitioner. Also heard Sri N. Ratan, learned AAG, as well as Sri
K. Derry.
K. Derry,
Yes, sir.
learned your CGC,
No, Your Lordship, appearing on behalf of.
appearing on behalf of Sri M. Kato, learned deputy SGI. Fourth, both the counsel for the respondents have submitted that affidavit in opposition have been filed.
No, Your Lordship.
They have not filed.
We have performed.
Okay, don't write that, huh? It transpires that while the state has responded to the writ petition, followed by a rejoinder filed today by the petitioner, the central, you would like to file affidavit?
They may like, my lord, it's a.
The central government has not yet filed the affidavit. Para, in view of the above, matter is adjourned to be listed on 25th of June, 2026.
8. It may be possible in 8, Your Honor.
8 what?
8 of this.
Let it be on 25th.
We'll grant them some time to file affidavit. 25th of June, 2026. By which time, the central government may also file the affidavit if so advised.
Yeah.
The rejoinder said to have been filed today by Ms. Sora. The learned counsel be brought on record, be tagged with the records.
Your Lordship, there is an interim, Your Lordship.
Interim order passed earlier to continue.
Interim orders, my lord. There are two interim orders.
Interim orders
Yes, my lord.
passed earlier to continue till the next date of listing.
Of nice.
Item number 12.
12. M. Nibo. Yes, Mr. Nibo.
My lord, the respondents are supposed to file affidavit, and the last for 2 occasions they have not filed.
Nobody has filed affidavit.
The respondent has not filed yet. And
Yes, my lord, I'm appearing on behalf of NPADA, respondent number 2. He is the standing counsel of tourism. My lord, Mr. NPADA is feeling unwell today, so
No, that will grant you time, but when are you filing the affidavit in opposition?
by next date, will
How much time?
2 weeks.
And one more, madam,
I'm for one chief secretary.
your affidavit would be required. Go by the tourism, okay.
For the last 2 occasions they have not filed. So
Third speak. M. Nibu, learned counsel for the petitioner. Also heard Ms. Wangmu, the learned state counsel, and Ms.
A. Talam.
A. Talam, learned counsel appearing on instruction of Sri N. Pada, Learned Standing Council Tourism Department.
Yes.
Full stop. Ms. Taram, the Learned Council has renewed the prayer for grant of time to enable filing of affidavit in opposition. Full stop. Three, Nibu, the Learned Council has, however, submitted that on 2 earlier occasions, time was granted to the respondent to file affidavit. In view of the above, comma, a final opportunity, in view of the above, comma, you'll have to file a final opportunity you are granting.
Yes,
No, 26 matter, okay.
3 weeks. Yeah.
Don't say anything. And let the affidavit be filed by the tourism department and the matter be listed on 1st of July 2026.
Yes.
You file it before that.
Most obliged.
Item number 13.
Sir, item 13.
May I please, my lord? In fact, this is second round of writ petition, my lord. My lord, while I was posted at Bandurwa, my lord, I was transferred, my lord, retained at Sagali, my lord, and in my place, my lord, one provisioner was, my lord, transferred, posted, my lord. That was, my lord, interfered by my lord, in a writ petition, my lord. Again, my lord, the same situation has happened, my lord. Again, I was replaced within a period of, my lord, 6 months, my lord. I was replaced by another, my lord, provisioner, my lord.
Now there's this interim order.
In status quo order, my lord.
Yes, you have
Yeah.
filed your response.
No, Your Lordship, at least 1 week time may be given, Your
Madam,
Lordship, for filing.
You have for the
counter-affidavit.
provisioner.
Yes, I filed my
You
affidavit.
have filed your affidavit.
Yes.
But state stand would be required. I think.
Yes, madam.
When do you file it? The matter is of which year? 26.
26 matter. Your
When can you?
But since your lordship, there is a status quo ante.
Mm-mm.
I had already taken charge on 15.
He's also
but-
he's also in the same office.
Yes.
But the status quo ante has been with effect from 12/5. So therefore, matter is urgent.
Let it be on Thursday, Your Lordship, coming Thursday.
Can you file by Thursday?
Yeah, okay, yes, sir. Our affidavits are almost ready, Your Lordship. Only
Okay.
Let them file by Thursday, my lord. In the meantime, we will also file a rejoinder.
That will be on Thursday. If you think that you need time.
Or can it be on Monday, my lord? Next Monday, my lord.
Monday, Your Lordship, it won't be possible.
Monday?
No, not this Monday, coming Monday, next Monday after I will.
Okay, we'll try on
It's
Monday.
quite urgent. Let the matter come.
1 week only.
1 week, my lord.
1 week. Thursday you'll not be there.
No, my lord.
You have to accommodate your friend.
I'm burdened with the status quo ante.
Okay. Heard Sri R. Saikya, Learned Senior Counsel assisted by Sri I. Bam for the petitioner. Also heard Ms. Pangu, the Learned State Counsel, as well as Ms. Dangan, the Learned Counsel for the respondent number 3. Full stop. Para. While the respondent number 3 has filed the affidavit, comma, the state is yet to file the response. Para. Ms. Pangu, the Learned State Counsel, has however informed that the affidavit is almost ready and would be filed soon. Para. In view of the above, matter is adjourned to be listed on 15th.
15, my lord.
I'm really sorry.
I'm Bharjagana. Oh, then on 16, my lord.
Tuesday, Lord.
16 is the DP, but you're taking your chance.
Tuesday.
17.
17, let them 17, my lord.
17 you are there?
7.
16 don't take a chance. DB, if it continues, you'll lose your chance. Okay?
17, my lord. Okay.
But file it, madam.
Your Lordship, 17th Wednesday, Your Lordship.
Wednesday what? Good.
Oh, okay, Your Lordship, 17.
Wednesday single bench.
Okay. How
But file it.
Item number 15 and 16.
May I, you know, so there is an interim, it may be continued, the status code.
Interim order passed earlier to continue till the next date of list.
Not.
Item number 15, 16. Yes, madam, what is this?
This I have for implement and
Implement, you are seeking implement.
Yes.
First time it has
yes,
come.
Your Lordship. Yes, Your Lordship.
Who are you?
Petitioner.
Understood, you are the applicant. Who are you? Why do you want this to
Applicant.
be implemented?
Your Lordship,
Oh, to
during the-
implement the NHPC?
yes,
You are the petitioner applicant.
yes, Your Lordship.
Okay, madam,
No.
who implement the NHPC? How NHPC is an affected party?
Yes.
Okay. Heard, what is your name, madam?
MLA.
Heard Miss M. Mele, learned counsel for the applicant writ petitioner, who by means of this application has prayed for implement of NHPC Limited, implement of the following incumbent, don't say
As such-
incumbent, as respond number 3.
Yes.
Then you write the name, NHPC entire with address. It is submitted that the said party is a necessary party who was left out while presenting the writ petition. Full stop. Also heard Ms. Wangmo, learned state counsel, who does not object to the aforesaid prayer. How are they connected, madam?
Here. WPC number 5.
Miss Mally, the learned counsel, by drawing the attention of this court to the averment made in paragraph 2, has submitted that the project in question has been handed over to the NHPCL.
Yes, Your Lordship.
First para, considering the above, this court is of the opinion that a case of implement as prayed for is made out. Full stop. Accordingly, the IA stands allowed and the incumbent named above is impleaded as respondent number 3 in WPC so and so. Para, IA stands disposed of. In the writ petition you write, wide an order passed today in IA number so and so. Implement of the following incumbent has been allowed. Write the name of the incumbent. Para, learned counsel for the petitioner is directed to file amended cost title within a period of a week. List after filing of such amended cost title. Second part is in the writ petition, okay?
Item number 18.
May I please, Your Lordship? Matter relating to non-payment of salary as per the refixation of pay under Section 7 Pay Commission, Lordship.
Non-payment of salary.
Yes, Lordship.
Yes, Mr.
Pension. Non-payment of pension, it's he has already retired. He's claiming pension as per the
Revised scale.
Yes, but in fact, we have justified that he is entitled to what he is getting.
You filed your affidavit.
Yes.
You filed your rejoinder.
Yes, Lordship.
So you'll have to hear this.
Yes.
For hearing.
Otherwise, he's getting the pension.
But he's claiming a pension at a higher rate.
Yes.
What is the basis of your claim, Mr. Gogol?
Lordship, I annex Lordship 5, Lordship, page 27 repetition, Lordship. Already, Superintendent of Transport Department issued a letter after retirement of my petitioner, Lordship, to refixation of pay, Lordship. That was the time, during the service time, he was not paid as per refixation of 6 and 7 Pay Commission payment, Lordship.
But after your retirement, do you still have a live claim? That is the issue.
Lordship, petitioner has received a letter from the...
Permissible. I think it is permissible if he is entitled.
If he is entitled, but this was exercised before his pensions were finalized, and this the very document he's relying on, the refixation of pay, that has not been accepted because it's miscalculated. Although
wrongly calculated.
Wrongly calculated. Although it was by the superintendent station superintendent, but later on it was found that this has been wrongly calculated.
Lordship, similar situated person has granted the same benefit, Lordship, as per fixation, Lordship. He has also indicated the affidavit in opposition, respondent number 3, Lordship.
Yes, if somebody else has got.
No, my lord, that in his reply they are saying that someone has been, that is from PWD department. We don't know about that, but
This is which department?
This is transport.
Lordship, kindly see the affidavit in opposition, respondent number 3.
We are wondering whether we can take up the hearing
Lordship,
today.
Lordship.
There are certain issues. But you are otherwise getting the pension, but you wanted a revised scale.
Yes.
Can we have some any other day?
Lordship.
Since tomorrow will be the last date, we have to finish off the matters. Mr. Gogoi?
Tomorrow, Lordship.
Tomorrow, don't take a chance tomorrow.
Lordship.
Tomorrow is the last date. This bench will not be available.
Lordship, 16, Lordship.
Can you try on Wednesday next?
Okay, Lordship.
Wednesday? Is it okay?
Wednesday.
Or any date which is convenient to you? 17th June we had asked, not 17th, today, 10th or 17th. You don't take 16. 16 is a DB day.
Lordship.
17 or 10th also you can.
10, Lordship.
10.
10 June, Lordship.
Okay. 10th. Third.
PK Gogoi, Lordship.
Gogoi, Learned Counsel for the petitioner. Also heard 3. N. Ratan, Learned AAG. Para. On a joint request, list this matter for hearing on 10th.
Lordship.
10th of June 2026.
Highly obliged.
You got that file?
That file is with the advocate, he's doing that correction. This is not the way to take from here.
Who's the advocate?
He told him to come, but he didn't bring. He is still there in the ground floor. He's doing the correction. This is not the way, Lordship. How can he do that?
What is the name of the advocate? What's the name of the advocate?
You call that advocate.
Name.
Name, उसका नाम क्या है? But that is not the way, Lordship. He is doing the correction there downstairs. Even we.
You cannot ask the court's records. It's a different matter. We allow inspection of records. But that is not the.
He told him to bring that file.
Mr. Ratan, you are member. Take up the issue.
Yes.
They may be new. They may be new in the bar, but they should know. What
Yes.
Mr. Tagum, you are senior members of the bar. You take up the issue.
Yes, really,
It's serious. They may not be aware. There are certain norms to be maintained in the court.
Yes.
Ask them. And he should come to the court, at least face the court. He may not know, but he should know. You're not supposed to touch the court's file. Inspection is different. Looking into the orders, the office notes is necessary. That is why we permit.
Second copy, main copy.
दोनों ही ले गया, main और second, दोनों को ले गया.
I am told it's petitioner's junior only.
Very unfortunate.
He has taken both the part 1 and part 2.
Who's the counsel, main counsel? Name?
Naban Saha.
Naban Saha, he was here.
Oh, Saha was there. He said, I do not know.
Not only that item is left, Lordship. So
Miss Junior only.
that peon has gone, call him, he will be coming.
Are you right? When this item was called, the court records were found to be missing. Full stop. The learned, the court master has informed. Yes, Mr. Saha, what is happening?
He is the one.
Lordship, actually, there is some, I think, he was checking for some extra copy.
Then why did you take out the file? Out of the court? Where did you get the authority to take out the file? And you are not owning the responsibility?
Yes, my fault.
You are arguing, you do not say that you do not know. How do you touch the court records? You don't know the decorum of the court. We allow inspection, that's a different matter. But can you touch the court records? You take it out of the courtroom.
Outside the courtroom.
You should know the procedure. These are not like this. You can do it with the permission of the court.
Yes.
He's right. When the found to be missing, the court master had informed this court that the learned counsel for the petitioner had asked for the records for inspection, and since then it is missing. Full stop. When the matter was taken up, called for the second time, the learned counsel has learned counsel for the petitioner. 3. What is your name?
N Saha, Navam Saha.
His name.
N Saha.
His name. Ansaha. You're in record or not?
Yes, it's on record.
And Tatam
It's not
had
on
entered
record.
the courtroom along with the original court files and has returned. Full stop. The aforesaid practice is absolutely unknown and is deprecated. Full stop. However, accordingly, however, considering that the council is new in the bar, this court has declined, has refrained from passing any strictures, while strictures and has directed the council to maintain the decorum for all future times. List this case after a week.
So Lordship, actually, Lordship, my humble request, Lordship. Lordship, because this is a serious case, because a tender is going to be open on 8th, Lordship.
After all this conduct,
Lordship, for that humbly, this one, humbly apology, Lordship.
do you think that you deserve an audience?
Yes, Lordship. Lordship, I do accept that one. I do sole responsibility.
Not there, Mr. Saha.
Yes, Lordship.
How do you pass an order? We have passed this order without the court records. Yes.
Sir, record has been brought, Lordship.
We do not know. Records have been brought after passing of the order.
Much obliged.